Okay, everybody, it's 4 o'clock, so I will start speaking to try to keep us on schedule. My name is Fiona Scott Morton. I am a professor of economics at the Yale School of Management, and I am also the founder and director of the Thurman Arnold Project at Yale. This is a project designed to provide antitrust programming to Yale students and the broader community, and do so in a way that is both rigorous in terms of the scholarship and also generates policy and deliverable ideas to make the world a better place and more competitive. I am just thrilled to be attending this great conference. I've really enjoyed the day, and I'm very excited for this final panel where we get to talk about reforms. We've had, of course, ideas for reform all through the day on other panels, but now we're going to focus a bit more intensely on this, and in particular in 3 different areas. So the first is general antitrust enforcement at the federal level in the food and agriculture industry. And then the second paper will be about chicken contract growers and protections that might improve competition at the state level. And our third paper is about food deserts and how they've been allowed to form, not be fixed, and some ideas about how antitrust enforcement might be a solution there. So before we move to our first presenter, Allison Johnson, let me remind the audience of our routine, which is presenters will talk for 5 to 7 minutes each. And after the presenters are finished, then we'll move on to Q&A from the audience. Please send me questions that you have in the chat or raise your hand in the Zoom function. And everybody besides the person talking, please stay muted during the presentation phase. So Allison's going first. Welcome, Allison. Thank you very much for presenting your work, and take it away.
Hi, thank you. All right, let me get my presentation queued up here for you all. All right, here we go. So I'm humbled and honored to be here with all of you, and I'm also surprised at the end of a long day of conferencing like this. I'm usually pretty tapped, but I am fired up. It's so exciting to see so many of you coming together and brainstorming creatively about how we take on consolidation in the food system, because it's a huge issue. So I'm Allison Johnson. I'm a staff attorney at the Natural Resources Defense Council, and I'm part of a team that's working to transition us from an industrial, exploitative food system to one that's just, healthful, and will carry us into the future. And we recognize that consolidation in the food system is a huge barrier to that vision. So I hope one thing you're taking away from today is that size matters. Justice Brandeis wrote on this extensively, and I love this quote from him, that size alone gives giant corporations social significance compared to smaller entities. Size relates to power. So in my paper, I've attempted to characterize some of the types of power that are at play in our consolidated food system. Our biggest players have the power to set prices and terms and figure out who bears those burdens. They can limit choice, they can influence public discourse and politics, they can confuse science, they can exploit the people who form the backbone of our food system, as well as the land we grow on, right back to the origins of the US food system on stolen land with the labor of enslaved people. They can fight in court, drawing out court cases, reaching settlements that are not necessarily in the public interest simply because they have more resources at their disposal. And ultimately, leaking back to Justice Brandeis's work, consolidated power puts decision-making in the hands of very few people. So our antitrust laws are designed to tackle that type of power. They were intended to keep power dispersed in the hands of many players to avoid outsized interest by any one party. Those laws have been sharpened and strengthened over the years as industry has found ways around them, but there's a lot of opportunity to return to those roots. So I'm going to just briefly touch on 2 key cases in the food industry that I think offer guidance about where we can go in the future. The first is Vaughn's Groceries. This was a case back in the 60s. right after there was an amendment to the Clayton Act that banned mergers to avoid substantially lessening competition. And what's remarkable about this case, if you go back to it, is that the Supreme Court recognized Congress was trying to stop concentration trends before markets ended up in the hands of a few big companies. It recognizes that power begets power. And so when power is already concentrated, it may be too late. So the Supreme Court here recognized that the Clayton Act is trying to stop mergers and trends toward concentration in their incipiency. And I'll just point out, this case has been questioned in the lower courts, but the Supreme Court has not overturned it. So I still consider bonds to be good law and something that can be resurrected in the courts. The second case was a loss that I think really helped steer the trajectory of our antitrust enforcement in the direction that it has gone through to today. So when Nixon came to power, he wanted to take on bigger cases. Vaughn's was a small grocery sector case, and he wanted to take on bigger issues. So the FTC brought a shared monopoly case against the biggest cereal companies. They dominated 90% of the cereal market. And FTC was positioned to win until industry flexed its power to influence. They launched a huge PR campaign that framed this case as an attack on American housewife's choice. They called the FTC the national nanny. These are narratives that you still see being used today to advance industry interests. And it was so effective that both Carter and Reagan promised to drop the case if they were elected, and Reagan did just that. So the other key piece here that I want to draw your attention to is the shift from making antitrust case law in the courts to making it in the executive branch through the enforcement agencies. In the late 60s and then strengthened in the 80s, the antitrust agencies started putting out merger guidelines. So these guidelines governed the agency's approach to enforcement. They broke from the case law by establishing these bright line numeric concentration rules. They focused on economic efficiency only, so this consumer welfare standard we've been talking about today, and they stopped examining this trend toward concentration that is so essential to the Clayton Act. So this morning, Christopher Leonard spoke really beautifully about our hopes and dreams for Obama on antitrust. Came in with these beautiful promises, launched a listening tour in ag country to talk about competition, and people were excited and hoped that our laws could be redirected in a helpful direction. And instead, he delivered two really important disappointments. The first was a report on those listening sessions that concluded antitrust laws didn't reach most of the competition issues that people had aired at great risk to themselves. So this reiterated this executive branch administrative approach to antitrust, and sorry, we can't do that approach that isn't necessarily rooted in the statutes themselves. The second was an update to the horizontal merger guidelines that expanded the safe harbors. So this means fewer mergers are challenged. And this update was framed as a neutral change, aligning with current practices, but the guidelines themselves recognized that the guidelines assist the courts in understanding and applying our antitrust laws. So over time, they have created a larger and larger safe harbor and resulted in less and less case law. So I'll just quickly touch on two opportunities that we have to redirect now through the executive branch our antitrust laws. One is those guidelines. We could reintroduce analysis of trends towards concentration and include an actual power analysis that considers social and political impacts of consolidation. We could also do away with these bright line numeric analyses that tend to, because of their tangibility and concreteness, tend to capture the attention of enforcers and distract from the broader social and political analysis. And then the second opportunity is to really ramp up litigation. Most antitrust cases are settled out of court, out of the public eye, and this has allowed a divergence of practice and case law. So seeing cases through to their finish with aggressive positions in court is one way we can resurrect some of these cases from the earlier years of antitrust. There are lots of opportunities we've heard about today to consider new theories. We could resurrect this shared monopoly approach that was taken in the cereal cases. And I'll just note that we need to recognize in doing this that the antitrust enforcement agencies need a lot of resources to do it because their opponents are extremely well resourced. And we need to anticipate the industry response in the public sphere. So it's not enough to go to court. We need a public campaign on these issues too. So there's lots to say. I'd love to hear from you if you're excited, you're skeptical, you're ready to join forces, and I'll look forward to questions. Thank you.
That's wonderful, Allison. Thank you. I completely agree about resources for the agencies. I mean, when you think about the amount of monopoly profit on the other side that companies are ready to spend to defend their monopoly profit, you see why the agencies need to be well resourced, and they're not. Okay, so we're moving on to the next paper on chicken. Jeamme, you're up. Thank you.
Great, thank you. I'm just going to share my screen and the presentation. One second. Can everyone see just the presentation, or are you seeing the notes as well? Good, okay, great. All right. Good afternoon, everyone. So my name is Jeamme Chia, and I'm a Master of Environmental Management candidate at the Yale School of the Environment. And today, together with my colleagues, Troncoso, Kathryn, Pogin, and Zoe Novic, I'm here to present our paper on a state-based Farm Fairness Act targeted at reclaiming liberty and improving transparency and fairness for poultry farmers in the United States. This white paper is the result of the Climate, Animal, Food, and Environmental Law and Policy Lab at Yale, where we investigated ways to create a more equitable and just food system for all. Specifically, we focus our attention and intervention on the poultry industry due to its unique structure, even within the highly complicated world of industrial agriculture. Fixing factory farming can be a complex and controversial issue, but something that almost every party can agree on is that contracts should be fair to small farmers, and we agree. We also believe that fairness in farm contracts can help address some of the additional environmental, health, and animal rights issues plaguing the American agricultural industry. But first, a little bit of background. Contract farming in the United States is the predominant way to raise chickens for slaughter. About 95% of broiler chickens in the United States are raised but not owned by contract farmers. Under the system set up by the largest poultry integrators, such as Tyson, farmers must pay huge upfront capital costs and bear the vast majority of risk in the operation. Integrators retain ownership of the chickens being raised and determine payment for the farmers through an opaque tournament system, in which performance of each farmer is compared to their neighbors. Farmers can easily get sucked into a cycle of debt, where they're asked under threat of contract cancellation to invest additional capital improvements to their barns. And because they're under such intense pressure to produce, the treatment of the animals under their care suffers, and workers suffer very real and well-documented psychological harms. On the flip side, anti-competitive practices have long plagued animal agriculture in the United States. The Federal Trade Commission found in 1919 that meat packers had created a monopoly that was exploiting workers and consumers. Congress passed antitrust legislation in response, the Packers and Stockyards Act of 1921. An enormous amount of advocacy has gone into trying to make the Packers and Stockyards Act do actually what it was designed to. In 2008, Congress directed the USDA to develop new and better regulation, leading to the GIPSA rule, so-called because of the Grain Inspection Packers and Stockyards Administration. This rule was popular with roughly everyone except large corporations. In 2010, though, Congress reversed, backtracked, and prevented the USDA from implementing regulatory reform. And in 2017, then Secretary of Agriculture, Senator Perdue, pulled the GIPSA rule completely. As it stands, the industry is actually even more consolidated now than it was 100 years ago. the failure to enact regulatory reform at the federal level aimed at generating fairer forms of contract in the agricultural industry has created an opportunity to states to intervene. Our proposed intervention is a model state-level legislative bill that seeks to utilize momentum surrounding the GIPSA rule to codify contract fairness, protections for farmers in state law. Our white paper contains more detailed information than what is presented here, as well as a draft text for the bill. In addition to looking at the federal regulations, we're also drawing on two successful elements of federal common law that sometimes aren't well utilized or actionable under state law: the implied covenant of good faith and the fair dealing and the implied warranty. Both of these are valuable protections for parties to a contract, especially where someone adheres to the letter of a contract but not the spirit. For example, the implied covenant protects against interfering with your ability to benefit from a bargain or your ability to perform your obligations. The implied warranty protects against deceptive practices, even when they might fall short of fraud, like coming to an agreement with a poultry grower only to send sick chickens for them to grow. We also conducted research into what protections the failed GIPSA rule would have provided to farmers, and identified 4 key areas where state legislation could play a role: anti-competitive practices, unequal treatment of farmers, coercion and unfairness by integrators, and the contracting process itself. We have found and continue to find examples of effective state regulation in each of these 4 areas. Some examples of these include banning confidentiality or secrecy in contracts and compensation, guaranteeing freedom of association for producers, prohibiting no-notice termination or non-renewal of contracts, and forbidding integrators from requiring farmers to continually upgrade their barns to raise more birds in less time and at lower cost. Combined with the implied covenant and implied warranty, they offer a compelling and comprehensive set of protections for small contract poultry farmers. We believe that our intervention has the potential to have cross-cutting benefits to the environment, farmers, and animals. By pushing for more equitable contracts through greater transparency, freedom of association, and fair financial compensation, we are trying to level the playing field and shift the economic and operational risks from growers to integrators. Contractual security and empowerment of growers creates opportunities and pathways for growers to pursue more animal-friendly practices. Farmers will have the power to decide how many chickens will be on their farms, how much space they will receive. We anticipate this will lead to more space per bird, healthier living conditions, and less chances of virulent pathogens. In thinking through where we would apply this intervention, we eventually identified the state of Virginia as a possible candidate for our proposed intervention. We recognize the need to be strategic about proposing these ideas and identify 3 factors that make Virginia a potentially viable state for reform. First, recent changes to the political alignment of the Virginia legislature. Since the 2019 state elections, Democrats control the governorship, Senate, and House. We estimate that given Democratic control of the state, it will be possible to propose reforms among more friendly representatives. However, the state continues to have significant Republican representation, making it purple enough that our proposed intervention could be politically significant if successful. That would likely fill in a gap that in a more historically progressive state, other forms of regulatory interventions might otherwise respond to. Second, broiler chickens are the state's top agriculture commodity, so reforms will affect a significant population of farmers within Virginia. Finally, in response to the USDA's 2020 proposed GIPSA rule, Virginia's Attorney General Mark Herring sent comment to the USDA calling for the adoption of the USDA's previous GIPSA rule. Given this context, we are hopeful the Attorney General's office will continue to support a state-level GIPSA rule as well. Looking forward, we expect to face 3 key challenges for our intervention, 2 of which involve preemption issues. First, the USDA has proposed a new rule that will set criteria to evaluate violations of the Packers and Stockyards Act, which in contrast to the 2010 rules, seeks to protect commercial behavior that is standard industry practice or custom. These rules face opposition from several states, including Virginia, and if promulgated, it will likely face its own legal challenges. Secondly, there are limits to a state's ability to regulate interstate commerce. They can design legislation to benefit the in-state economy And the regulation enforcing fair contracts may be seen as a violation of the Dormant Commerce Clause. Finally, due to COVID, non-emergency policies have been put in the back burner, as we have seen, and we expect a challenging policy environment in the near term. Nonetheless, we believe that our intervention and research will still provide a useful framework for advocates and will be addressing these issues in our white paper. Thank you.
Fantastic. Thank you, Jeamme. I guess I have a question, which I'll just raise quickly before introducing Christopher, about the state level enforcement. Like if you did something, so all of this transparency stuff, fantastic. I'm for it. I think it would work beautifully at the federal level. I worry a bit about Virginia adopting it and then the manufacturers leaving Virginia and putting their chicken farms somewhere else. And then Virginia loses jobs and the people are upset and so forth. So we need to think about the free riding there. Okay, but I'm not going to let you answer. I'm going to turn to Christopher Leslie and we'll enjoy that paper here about food deserts and then open up the Q&A. Thank you, Chris.
Thank you so much, Fiona. I assume I'm last at the conference because I'm that last leg in the food distribution system of getting the food to consumers.
And we saved the best for last.
Well, we'll see. Scholars use a desert metaphor to describe urban neighborhoods and rural regions where residents don't have access to healthy food. These food deserts are areas of food scarcity where healthy food like fresh fruit and vegetables is unavailable. Food deserts are defined by, in part, proximity to the nearest supermarket. That's 1 mile in urban areas and 10 miles in rural areas. Many of the low-income residents in these areas don't own cars and don't have access to public transportation that they can use to get access to affordable food. Studies have identified 6,500 food deserts in America, and they're in every region of the country. The USDA has estimated that 23.5 million Americans live in food deserts. More recent research puts that number closer to 30 million. The lack of proximity to supermarkets has significant health consequences. Without supermarkets selling fresh produce, food desert diets are much higher in fat, salt, and sugar, which translates into higher rates of obesity, heart disease, hypertension, and diabetes for people who live in food deserts. Millions are suffering. But it didn't have to be this way. During the early 20th century, urban residents enjoyed competitive markets for fresh produce sold by small independent grocers. But then during the Great Depression, the supermarket was created and it grew in numbers to 1,200 supermarkets in 1936 and quintupled to 6,000 4 years later. With mom and pop grocery stores largely vanquished, city dwellers relied on supermarkets. This dependence proved tragic once the urban demographics began to change. As more African Americans and recent immigrants moved into urban centers, racial tensions arose and white flight took over. Government at the federal, state, and local level subsidized this white flight to the suburbs through policies like mortgage discrimination, highway construction, zoning, utility development, school construction. Between 1950 and 1970, the population of the suburbs doubled from 36 million to 72 million people. And supermarkets soon followed white consumers out to the suburbs. Focused on suburban dollars, supermarket chains shuttered their older inner city locations. One government study showed that, quote, 90% of the conventional grocery stores located in low-income neighborhoods that either closed or voluntarily or went out of business did so that they could relocate to the suburbs. White flight played a major role in creating urban food deserts. African Americans could not follow the supermarkets out to the suburbs, first because of racist laws, and when those were invalidated by private racial discrimination in the form of racial covenants. Yet even after the Supreme Court invalidated racial covenants in residential real estate, segregation continued because of discrimination by the FHA and by local real estate agents, as well as harassment and violence of Black households. Part of this legacy is that many food deserts are racialized. Half of the Black neighborhoods in our country don't have a supermarket or a full-service grocery store. Food deserts are not merely the unintended consequence of supermarkets focusing on suburban consumers, however. Many food deserts are the result of a premeditated strategy by supermarket chains to deprive certain neighborhoods of grocery stores. This story involves covenants. Supermarkets negotiating leases with commercial landlords will often demand an exclusivity covenant that prevents that landlord from leasing another supermarket in that same shopping center. These covenants are common and are generally uncontroversial. But there's another type of covenant that deserves more attention. Lack of space is the critical barrier to entry for supermarkets in cities. One major reason that appropriate space is unavailable is that major supermarket chains use restrictive covenants that forbid their sold property from being used as a grocery store for decades to come. In my article, I dubbed these scorched earth covenants. These scorched earth covenants have created and preserved food deserts across the country. You might ask, why would an exiting supermarket impose a scorched earth covenant that deprives the inner city neighborhoods of affordable food? And the answer is simple. They're trying to prevent competition for their remaining locations that are within driving distance of their abandoned location. Although food deserts are defined by half of the residents being low income, half of the residents in many food deserts are not low income, and they do have cars, and they are capable of driving to the suburbs in order to buy groceries. The Scorched Earth Covenant is designed to encourage that behavior. But for those food desert residents without cars, they're left without any means of buying healthy food. In addition to these scorched earth covenants, some food deserts are created by supermarkets closing a store in a location they own and then simply leaving the building vacant, a practice known in the industry as going dark. This going dark strategy is not limited to landowners. Supermarkets sometimes will abuse their exclusive use covenants by taking a lease that prevents the landlord from leasing a space in a shopping center to any other food seller. The supermarket will then abandon its location in that shopping center, will leave it empty, but will continue to pay rent so that nobody else can sell food from that shopping center because of the exclusive use covenant. My project discusses how food deserts should be considered an antitrust issue. Antitrust claims challenging anti-competitive tactics like going dark schemes and scorched earth subleases have generally failed. This surprises me. Because scorched earth covenants inherently unreasonably restrain trade, but courts aren't particularly receptive to antitrust claims. There's a couple of reasons. The reason I'd like to focus on in the talk is that judges define relevant geographic markets incorrectly. Most antitrust claims, including antitrust claims challenging mergers, monopolization, and anti-competitive agreements that are evaluated under the rule of reason, require market definition, including definition of the relevant geographic market. When analyzing antitrust claims against supermarket restrictive covenants, courts treat the relevant geographic market as the metropolitan area, meaning the entire city and the surrounding suburbs. For over 60 years in merger cases, beginning with Vaughn's, courts have been reluctant to define geographic markets as narrowly as neighborhoods because judges assume that all consumers have cars. For example, when the FTC recently challenged the Whole Foods acquisition of the Wild Oats supermarket chain, the district court accepted the agency's definition of the relevant geographic market as competitors within a distance of 3 to 6 miles of their stores and roughly 16 minutes of driving time. In non-merger antitrust cases as well, courts often define relevant geographic markets for supermarkets based on the behavior of the most well-off consumers with cars. In 1998, in the Tops Markets case, the Second Circuit rejected antitrust claims challenging a supermarket's anti-competitive conduct in Jamestown, New York, including the defendant purchasing land and then blocking competitors with a scorched earth covenant. The Second Circuit defined the geographic market as a 7 to 10 mile radius around the city of Jamestown, which effectively eliminated the plaintiff's monopolization claims. Today, 20 years later, Jamestown, New York is a food desert. Thousands of people in Jamestown do not have access to healthy food like fresh fruit and vegetables. Nationwide, removing these restrictive covenants can help solve the problem of food deserts. Where deed restrictions are not a barrier to entry, new grocery stores have taken over abandoned supermarket spaces in places like Chicago and Vallejo, California. Antitrust should take aim at these restrictive covenants. First, the definition of food deserts should inform how courts define the relevant geographic market in antitrust litigation. For millions of individuals who live in food deserts and who lack transportation, their neighborhood is the relevant geographic market. The failure to recognize this distorts antitrust analysis. It makes unreasonable restrictive covenants seem reasonable. It makes monopolists seem like they face competition. It makes mergers seem like they leave consumers unaffected. Properly defining the relevant geographic market in antitrust litigation can help solve this problem. Beyond defining the geographic markets better in antitrust litigation, antitrust agencies should use the leverage that they have during the merger review process to try to strike down scorched earth covenants and to encourage supermarkets to re-enter food deserts, perhaps as a condition to agencies not challenging a proposed merger. While advocating a greater role for antitrust policy, I know that antitrust law alone can't solve the problem of food deserts. Any solution to food deserts is going to ultimately have to be multi-pronged, but one of those prongs should be a more thoughtful wielding of antitrust tools. In conclusion, food deserts are a story of failure. Markets have failed. Supermarket chains have failed low-income consumers when they abandon the inner cities and focus on suburbs and scorch the earth behind them as they leave. And antitrust law, in turn, has failed the residents of food deserts. However, if we use antitrust enforcement to try to increase the supply available for healthy food, this could go a long way to remedying the problem. Thank you.
Super.
I think I might have beaten Austin's land speed record.
It was fast, but it was really interesting. Thank you very much.